sexually violent or sexually motivated offense. State.
The state has provided discovery in this case and is not aware of any exonerating DNA evidence.
Mr. Esposito, have you had sufficient time to review the discovery of this case and discuss it with your client?
I have.
And are you aware of any physical evidence that can be tested for DNA that might exonerate her?
No, sir.
And are you willing to stipulate to a factual basis for the charge?
For the purpose of the plea, yes.
I do find a sufficient factual basis for the charge of felony battery. I accept your plea. I find it's entered into freely, voluntarily, and intelligently. You are coherent and alert, and that you understand the nature of the charge and the consequences of your plea. I will withhold adjudication, place you on 36 months of probation with the following special conditions. You must complete an anger management program. You must complete 50 hours of community service. You are to have no contact with the listed victim. You are trespassed from returning to the no-name bar. You must pay standard court costs plus $100 cost of prosecution, $100 cost of investigation, and I will reserve on restitution for 60 days.
And Your Honor, once we get the restitution amounts agreed upon, we would ask for a minimum payment of at least $50 a month on the restitution.
Whatever you all come up with.
Yes.
All right. Ma'am, you have 30 days to appeal the legality of this court sentence. If you wish to appeal, we cannot afford an attorney. One will be appointed for you. All right, we'll step over there. You can meet with our probation officer and get started on your probation. All right, State, you may call your next case.
Yes, sir. State versus Anthony Guadalupe.
All right. State versus Anthony Guadalupe. Mr. Probisco, good morning.
Good morning, Your Honor. Here on behalf of Mr. Guadalupe, who's present in good order before the court.
All right.
He is before the court on a 14-count information charging 12 counts of lewd and lascivious molestation by a person 18 or older on alleged victims under the age of 12, and 2 counts of lewd and lascivious exhibition by a person 18 years or older on a victim under the age of 16. We have a executed plea form here, Your Honor, and what it states is that Mr. Guadalupe is in a position this morning to withdraw his previously entered plea of not guilty. He'll be entering guilty pleas as charged to all 14 counts in the information. The negotiations with the state are such that he has a score sheet which we've reviewed with Mr. Guadalupe. For the record, it's 795 months, which equates to approximately 66 years in prison. The proposed disposition would be a waiver of those guidelines with the essentially the bottom sentence being a 35-year sentence up to life. What we've instructed Mr. Guadalupe on and what's set forth in the plea form is that in the event of a sentence less than a life sentence, Mr. Guadalupe understands that he'd be subject to lifetime sex offender probation. He'd be subject to sex predator registration, no contact with any of the victims of the families, cost of prosecution, cost of investigation. As to counts 13 and 14, there's an agreed 15-year DOC sentence to run concurrently with the counts 1 through 12, and the only other legal quirk that we've advised Mr. Guadalupe on is the fact that under this particular statute there is no game time eligibility for any sentence that's imposed.
All right, so the guidelines are being waived. The agreement that the minimum sentence is 35 years.
Yes, Your Honor.
And is that the minimum mandatory?
The minimum mandatory is 25 years, so the exposure is 35 years to life.
Got it. So in exchange for the state waiving the guidelines, the minimum sentence that the court can impose would be 35 years in Florida State Prison, up to life in prison, and then lifetime sexual offender probation to follow, and a registration as a sexual predator and no contact with the victims.
Yes, sir.
That's correct, Your Honor.
Okay. All right, and the victims have all been advised of this plea agreement, and they're in agreement with this as well?
Yes, sir.
Okay. All right, you've had sufficient time to discuss this decision with your client, Mr. Probisco?
I believe so, yes, sir.
And we would set the matter off for a sentencing hearing. Is he entitled to a PSI?
He is, and we'd request one.
Okay, so I would order a pre-sentence investigation. That will take some time. When would you all like to come back for sentencing?
We had tentatively proposed a date in docket setting in December, kind of as a to-be-set date, Your Honor.
Okay. December 6th would be the docket setting, so we would set it as a to be set on that day and then pick a day during the 2-week trial period for the sentencing hearing.
Understood.
All right, Mr. Guadalupe, you just heard your attorney tell me that you'd like to enter a plea to these charges and the terms and conditions of the plea agreement. Is that what you'd like to do this morning, sir?
Yes, sir.
All right, raise your right hand. Do you swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
All right, state your name.
Anthony Josiah
You can put your hand out and speak into that microphone, step into that microphone a little bit closer, please, and state your name again, please.
Anthony Josiah Guadalupe.
How old are you?
I'm 20.
You can put your hand down. How far did you go in school?
High school diploma.
Are you able to read, write, speak, and understand English?
Yes, sir.
Are you under the influence of any medication, drugs, or alcohol?
No, sir.
Have you ever been diagnosed with any type of a mental health condition that might affect your ability to understand what's happening here today?
No, sir.
Your attorney has just informed me that you would like to enter a plea of plea of guilty to 12 counts of lewd, lascivious molestation on a person less than 12 years of age, and 2 counts of lewd, lascivious exhibition in the presence of a person less than 16 years of age. The first 12 counts are all life felonies, which are each punishable by up to life in prison. The last 2 charges are those second-degree felonies, which are punishable by a maximum of 15 years in Florida State Prison. I have a guidelines worksheet, which the state prepared and has shown to your attorney, which indicates that the minimum sentence under the guidelines would be 795.600 months. However, in exchange for your plea today, the state has indicated they're going to waive the guidelines, which allows the court, or would permit the court to go below that sentence, with the agreement that the minimum sentence that the court could impose would be 35 years in Florida State Prison. The maximum sentence that the court could impose would be life in prison. It would also be, if the court does not sentence you to life, but does sentence you to a term of years for your prison sentence, that would be followed by a lifetime of sex offender probation. You would be required to register as a sexual predator, and you would be ordered to have no contact with any of the victims in any of these charges. Is that your understanding of the plea agreement?
Yes, sir.
Is anyone forcing you or threatening you in any way to get you to do this?
No, sir.
Has anyone promised you anything in exchange for your plea?
No, sir.
I have a document here. It is the plea form. It is the 3-page document, and on the last page above the word defendant is a signature. Is this your signature?
Yes, sir.
And by signing this document, are you indicating to me that you have read this document in its entirety?
Yes, sir.
In addition to reading it, did you go over everything and discuss everything that's contained in it with your attorney?
Yes, sir.
Did your attorney go over all of the rights that you'll be giving up if I accept your plea today?
Yes, sir.
You understand that you have the right to a jury trial. During that trial, you are entitled to be represented by an attorney. If you could not afford an attorney, I would have appointed one for you. You and your attorney could have required the state of Florida to prove each of these charges beyond a reasonable doubt. You could have remained silent during that trial, or you could have testified if you wished. You could have presented evidence, compelled witnesses to testify on your behalf. You could have cross-examined any witnesses that might have been called against you, and you could have appealed your conviction and sentenced to a higher court. You understand that once I accept your plea today, you'll be waiving all of those rights, and there will not be a jury trial in your case.
Yes, sir.
Have you had sufficient time to meet with your attorney and to discuss your case with him?
Yes, sir.
Have you and he discussed any possible motions that he might have filed on your behalf?
No, sir.
You've not discussed any possibility of any defenses or any motions that your attorney could have filed on your behalf?
Can we talk about the evidence and the likelihood of trial outcomes?
Yes, sir.
Have you talked about your case with your attorney?
Yes, sir.
And have you and he discussed the possibility of any possible defenses that you might have raised to these charges?
Yes, sir.
And did you discuss the decision about whether or not to go to trial versus entering this plea with him? And while he has advised you on this decision, you understand the decision to waive your right to a jury trial to enter this plea is solely your decision. Your attorney cannot make that decision for you.
Yes, sir.
You understand that?
Yes, sir.
And is it your decision to enter this plea?
Yes, sir.
Do you need any more time to speak with your attorney about your case, about anything about your case before we proceed?
No, sir.
Are you satisfied with the representation that you've received from your attorney?
Yes, sir.
Did your attorney explain to you that if you are not a U.S. citizen, that entering this plea could result in you being deported from the United States?
Yes, sir.
Additionally, I need to advise you of your, what we call our Jimmy Rice law. I want to make sure that your lawyer has advised you that because you were entering a plea to a sexually violent or sexually motivated offense, under statute section 394.912 of Florida statutes, your plea in this case could subject you to the provisions of the Jimmy Rice Civil Commitment Act under Florida statute 394.910, which would allow the state to commit you to a secure treatment facility for an indefinite period of time as a person who has been convicted of a sex offense and who is determined to be likely to commit a violent sexual offense in the future. Has your attorney discussed that issue with you as well?
Yes, sir.
And do you need any more time to speak with him about that matter?
No, sir.
State, have you provided all the discovery in this case to the defense?
Yes, sir.
Are you aware of any physical evidence that can be tested for DNA that might tend to exonerate him?
Not that would exonerate him, no.
Mr. Provisco, have you had sufficient time to review the discovery in this case and discuss it with your client?
Yes, Your Honor, we've reviewed all of the video evidence, the interviews, specifically the DNA analysis in the case, and we're unfamiliar with any outstanding evidence